Jury selection is set to get underway in LA today in a trial against three of the world's biggest social media companies. You've got Meta, TikTok, and YouTube. They're accused of knowingly designing their platforms to be addictive and harmful to children.
That's right. Kelly Stonelake worked at Meta for 15 years. She says while she was there, the company took extra steps to ignore red flags, suppressed research on children's safety, and created a breeding ground for predators.
And I see this pattern play out in the products that Meta and other companies like it offer to protect kids. For instance, a few months ago, Instagram rolled out teen accounts under kind of quite a bit of legislative pressure. But independent review of and auditing of these features found that almost half the time they didn't work.
Interesting. Trial attorney Rachel Fezay joining us now with more insight on the case. Everything we're saying there doesn't sound good, but thank you for joining us this morning.
Thank you.
So let's talk about the legal claims being made in this suit against Meta, YouTube, and TikTok, and we should also say Snapchat has already settled.
Yeah, so there are claims, various torts relating to the harm that these companies are doing to children. And basically what needs to be shown here is that they knew or should have known that this harm was going to happen as a result of the technology that they were using in order to make basically teens and children continue to scroll, and that it was harmful to their mental health and other things.
I mean, these are pretty serious allegations here. But the case is already being described as a landmark case for social media litigation. Can you explain why that is and how this could actually, create a domino effect potentially?
Well, there are actually over 1,000 of these cases progressing through the system, and the case that starts today is the first one. So in the legal world, that's called a bellwether case. And what the bellwether case will do is essentially set up liability for all of those other cases. So if in this case, the YouTube and the social media companies are found liable, it's basically going to affect all those other cases behind it. And I bet then you will see thousands more progress. So this case is essential, even though it's just one case, it's essential to all of the rest of them going forward.
Interesting. Many call this the tobacco trials of our generation. Talk about the similarities there in having a company put out something that potentially they knew was harmful and now going to court for defendants to prove that.
So that's right. It's whether the company knew it was harmful. Same with tobacco. Did the tobacco companies know this caused cancer? Did they advertise anyway relating to kids and adults without saying the health risks? And it's basically the same exact analogy we're getting here. Did the companies know this was harmful? Did they advertise in the same way to get people addicted, in the same way one might be addicted to tobacco, knowing it would cause harm in the process? And so that's the analogies. I think in tobacco companies, you have science relating to serious health effects and otherwise, but here it's going to be mental health science. And so it may sound softer to some, but that is essentially the analogy about these cases.
Well, that's what I was going to ask you about, though, because I think, when people have data in front of them and they have maybe family members who, they smoked and they did get cancer. Oh, they did have heart disease. They see the actual physical medical condition. But with mental health disorders, a lot of times, they can be subjective in some ways as to how they came about, if there were other things. This is going to be a very challenging case, potentially, to get juries to buy in here.
That's right. I mean, I think that mental health help and disorders are a science, but you need the jury to buy into it, and you need to understand the symptomology of it. And they will have to have health records going forward. They have to show that these the plaintiffs would not have had these mental health disorders without the social media. There's a lot that goes into what we call causation. So they have to show that the disorders were real and they were caused by these social media companies. So that's that's really going to be a big trick that kind of comes at the end, where you have knowledge and they've acted recklessly or negligently to cause this addiction. They knew that it could cause harm, and then we get to the end and the plaintiffs have to show it did cause the harm.
This is all very, very interesting. Thank you so much for helping us understand it more. We'll continue to follow this case, Rachel.
Thank you.